So welcome everyone to this fall's public policy forum. This is several of us met last week to talk a little bit about it. This is really our first evening looking at issues of democracy in America. Tonight we have Professor Teachout with us, and we have members of the community zooming in. For those in Eileen's class who are zooming in, as well as community members, feel free to, when the time comes, put questions in the chat, and I'll ask Ms. Provided to answer those questions. For those of you that have not had an opportunity, I know that there are several students who are here for a class that were asked to take a look at and learn a little bit about Professor Teachout. For those of you who have not, let me tell you a little bit about him. Professor Teachout is recognized for his expertise regarding constitutional law and history, the constitutional law and history of Vermont and the United States. He has taught many courses during his career at Vermont Law School, including courses on constitutional law, international regulation of trade, legal history, jurisprudence, argument and culture. Professor Teachout received his BA degree from Amherst College and his JD from Harvard Law School, where he was the John Woodrow Simpson Fellow. He received his MA degree from the University of Sussex. He served in the Department of Intelligence of the United States Army from 1966 to 1969. And he has joined the Vermont Law School faculty in 1975. Since then, he has also been a National Endowment for the Humanities Fellow at the University of Chicago, visiting fellow at Cambridge University and Dartmouth. His expertise is frequently tapped by Vermont's legislature and judiciary. And that is how I first got to know Professor Teachout. Over the years, Professor Teachout has been incredibly helpful to the Vermont legislature. He has been, without a doubt, the legislature's right-hand person when it comes to questions of Vermont Constitution as well as the U.S. Constitution. We're going to talk a little bit about those things this evening. We're going to talk about the courts, and we're going to talk about the current situation facing the courts and the United States. But before we do that, please join me in welcoming Professor Teachout.
Thank you, Brian. It's always great to be introduced because you see your whole life. Great. Except for my grade school experience in Montpelier, Vermont.
What's that? Sure, we'll switch.
What are we doing?
We're good? How's that?
How's that?
Great.
Okay.
So thank you, Professor Teachout, for being here, and thank you all for being here, even some of you who are required to be here, thank you for being here. This is an interesting and important conversation, and we're talking with Professor Teachout tonight about the courts, specifically the Supreme Court. And he and I were just talking a little bit, and I wanted to kick off the conversation with, we have heard in the media, we talk about it here on campus, we hear it a lot when we're talking to our friends, that we're in this state of crisis, that the courts are in a moment of crisis. And I wanted to just get a sense from Professor Teachout whether or not he believes that's accurate, that we are in this moment that is in some ways unrecognizable to Americans if you were to look back in the history of this country. So I thought we might start with that.
So, Brian, I agree. It's a good place to start. The theme of this series is the Constitution, the courts, and the crisis in democracy. So why this sense that somehow the Supreme Court is related to what we all perceive to be a kind of crisis in our democratic institutions? So it's interesting to go back to the very beginning. For the 10-year period from the time of the Declaration of Independence until the Constitutional Convention in the summer of 1787, and the time the Constitution was ratified, there was an American government, there was a national government, but it consisted simply of a single Congress that met once a year in which each state had equal representation. There was no executive branch, there was no judiciary. The document was called the Articles of Confederation. You don't need to remember that, but that's what we had for a full decade between the Declaration of Independence and the adoption of our Constitution. Now, during that time, states had ripped up their old colonial charters and begun to experiment with state constitutions. So they all had some experience under their belt, 10 years of experience by the time the Constitutional Convention in the summer of 1787 took place. And the framers took advantage of that experience in coming up with the basic outline of what we call our Constitution. Now, one of the important differences is that for the first time, the Constitution was going to consist of a legislative branch, an executive branch, and a judicial branch. And that's where the Supreme Court comes in. The Constitution itself is divided into several parts. The first part deals with legislative power, the second with executive power, and the third with judicial power. The third article is really very spare in terms of whatever provisions it makes for the creation of a federal court system, at the very top of which was to be the Supreme Court. All it says is that there shall be a Supreme Court and such inferior federal courts as Congress shall deem warranted. Now, when the Constitution went out to the states to determine whether it would be ratified in conventions in each of the states, proponents of the new Constitution produced what are called the Federalist Papers. Madison and Jay and Hamilton were the three writers. They wrote under anonymous names, Publius and things like that. But anyway, it's a very partisan document. They were trying to promote the idea that adoption of the Constitution was a really good idea. It was a good idea because it dealt with some of the key problems under the Articles of Confederation. Under the Articles, the national government had no power at all to raise revenue. They could go to the states and ask the states, hat in hand, to contribute their portion of national costs, but they had no power to compel the states to do so. The national government had no power to prevent the states from engaging in tariff wars between the states. New York might impose a tariff on chairs coming in from Connecticut, and then Connecticut would impose a tariff on shoes coming in from New York. And the whole economy was coming to a standstill because of this barriers to interstate trade that had grown up. There were other serious problems under the Articles. Basically, it was a federal government that looked a little bit like the United Nations, a league of friendship, it was styled, but with no real powers. So now we've got a proposal on the table to create a real government at the federal level, and as part of that government to create a set of federal courts, at the very top of which would be a Supreme Court. Now, one of the interesting things, if you read the Federalist Papers, and Hamilton wrote Federalist Paper number 78, he argues this court, it will be the least dangerous branch, that was his term, of the federal government. Why? Because it doesn't have the power of the purse. It's got no power to raise money or spend money. Because it doesn't have the power of the sword. It's got no power at all to engage us in war or other kinds of conflicts. It's the least dangerous branch. What can it do? Maybe it can review legislation from time to time, and if Congress has clearly exceeded its power, it could deal with that problem, but the least dangerous branch. Now I want to fast forward to today. And today, I will tell you, colleagues of mine who are well-established constitutional scholars, Larry Tribe from Harvard Law School, for example, argue that the Supreme Court of the United States is the most dangerous branch of government, that it represents, and this is his term, not mine, an existential threat to our democratic institutions. So what we want to talk about tonight, and I hope in subsequent sessions in this series, is what does that mean? In what respects does the Supreme Court this least dangerous branch, represent an existential threat to our democratic institutions. And one manifestation of that concern is reflected in a series of decisions that this court has made over the last, up to 10 years, but primarily in the last couple of years. And what are those decisions, and why do they impact the operation of our democracy and the integrity of our democracy? One, the court has refused to get involved in blatant partisan gerrymandering. It's not a problem in this state, but in many states, even if you were a member of the party that clearly controls 80% of the population, you might end up electing only 2 or 3 out of 10 representatives to Congress. Partisan gerrymandering really is corrupting what we would consider to be the healthy operation of a democratic system, in which those in majority, in fact, get majority representation in Congress and in the state legislatures. Okay. The court says we aren't going to deal with that. We can't find manageable standards. I will tell you, state courts have found manageable standards, but the Supreme Court says we aren't going to get involved in it. So it lets partisan gerrymandering go on. That is a real threat to democracy. Second, the court struck down federal legislation adopted by both parties attempting to control the flow of dark money into the political process, into political campaigns. We can come to that case later on if you want to do so, but that's the Citizens United case. The court struck that down, saying this interferes with the free speech rights of corporations. What does that mean? It opens the purse strings for increased obscene levels of expenditures, in my view, in political campaigns. That also is corrupting the way I think a democratic system ought to work. Third, just this year, the court issued a ruling limiting the ability of federal agencies, in this case, the Environmental Protection Agency, to adopt reasonable regulations aimed at curbing the problems of climate change. It adopted a fairly novel doctrine in doing so, saying if you want to exercise this power, you can't do it now because Congress has not explicitly authorized you to exercise this particular form of regulation. Okay, so it's disabled, and it may do so again in the future, federal agencies from dealing effectively with the problems of climate change. Third or fourth, it struck down a state law in New York, which it seems to me was a reasonable effort to deal with gun violence. And I suspect the Second Amendment will be deployed in future cases to strike down other state laws limiting and regulating the ability to bear AK-47s or whatever else people want to bear. So that's a problem too. It is also in a series of decisions which we may talk about tonight, or I'm going to stop here pretty soon. We won't have time to talk about anything. Okay. It's also issued a series of decisions that really weaken the wall of separation between church and state. In fact, issuing decisions that almost force states to end up using taxpayer money to fund religious instruction and the propagation of particular religious views. That to me is a serious problem as well. It has transformed what we call establishment, anti-establishment provisions in the Constitution and free exercise provisions in the Constitution to achieve that result. One of the cases that we might talk about tonight is the Carson versus Macomb case involving a challenge to a Maine tuition reimbursement program, very similar to what we have in Vermont, in which the court said you can't do it if you're going to fund private school education or provide tuition reimbursement for private school education. You cannot discriminate against those parents who want to send their kids to pervasively religious schools. And then finally, I mean, these are,
Yeah.
okay,
Go ahead.
okay, fine, okay, then I will stop. I just want to get this stuff out there, and
Yeah.
you can open these various avenues later on. And then finally, it's the Dobbs versus Whole Women's Health of Jackson, Mississippi, in which the court overruled a precedent that had existed for 50 years in our system, the Roe versus Wade case, which really has a profound impact on the protection of our constitutional rights, and particularly a profound impact on the rights and equality of women in our system. So you take a look at all those decisions, you see, and what's common about them is they all seem to line up around a particular partisan agenda. It's not accidental, because that's what the judges see as their mission. But in any event, that's disturbing too. And then I would just add the last shoe, which is many of the justices on the current court are going to be there for a long time. They're in their 50s, a couple in their 60s, but that means they're going to be sitting on the court for the next 20 or 30 years. So we're looking at a future in which we can expect a court to pursue a partisan agenda. And what recourse do we have? So that's,
No, that's great. That's,
I wanted to get that out there. That's the crisis, as I see it, or at least as many of my colleagues see it.
so would you say if some of these issues had come before the court 50 years ago, 40 years ago, 30 years ago, for example, you know, the issue with Citizens United, for example, the court may have found that decision, may have come to a different conclusion, saying that corporations aren't people?
Well, that's interesting, and it's difficult to know about
Sure, I mean, but
30 years or 40 years, but I will tell you, basically, we think of courts in terms of the chief justices.
Mhm.
Up through 1969, the court we referred to as the Warren Court after Chief Justice Earl Warren. That was a very liberal court. Now, I'm sure conservatives may have been just as concerned about some of the liberal court decisions as we are about the conservative court decision. But 1969 is generally the watershed, because after that, Chief Justice Berger was Chief Justice, then Rehnquist was Justice, and now Roberts is Chief Justice. And all of those three courts have pursued a pretty consistent conservative agenda. But it's not as clean as that, because I will tell you, Justice Kennedy, who sat on those conservative later courts, issued some incredibly important rulings for the court during that time. For example, the ruling that adult sexual intimacy is a protected privacy right that cannot be interfered with by a state without a compelling interest. That court also ruled that same-sex marriage was a constitutional right that cannot. So it gets a little bit complicated, but the general pattern is pretty clear, and the pattern is getting starker and starker as we move toward the current day.
Does that have something to do with how we're choosing our justices, or how justices are being put forward? Has something changed over the past X number of years? Are our presidents, I mean, I think maybe it's obvious that yes, but the way Kennedy may have chosen somebody, or Ford may have chosen somebody, has something dramatically changed?
I don't think it has dramatically changed, but the way it works is the president gets to nominate a justice of the Supreme Court subject to the advice and consent of the Senate. And the hearings that the Senate conducts to determine whether to approve or disapprove the president's choice are called confirmation hearings. In my view, they have become routine. They've become showplaces for the senators who ask questions, but the questions that are asked of the justices are not at all revealing. And indeed, to the extent they indicate or suggest how a justice may rule, they have been quite disappointing, because all three current conservative, most conservative justice, the young conservative justice, Gorsuch, Kavanaugh, and Amy Coney Barrett, all said in their confirmation hearing, we view Roe versus Wade as settled law. They didn't go much beyond that. They didn't say how we're going to rule, but we view it as settled law, indicating that they would be very reluctant to overrule it. But they weren't at all reluctant to overrule it when the court first had a shot at it this year in the Dobbs versus Mississippi case.
So maybe the question, I guess I knew that the process was still pretty much the same, but it seems in some ways that presidents are now looking for people who may be more partisan. And I don't know, was that always the case? I mean, I think of Gerald Ford saying, you know, his greatest accomplishment, he felt through his very brief tenure as president, was his choice of, I can't remember the justice off the top of my head.
Not Souter. What?
No, it wasn't Souter, but
Yeah.
it ended up being somebody that, you know, might not necessarily have been conservative, if you will.
Justice
Stevens, yeah, John Paul Stevens.
Yeah, Justice Stevens, who was a Republican, and a Republican favorite, but both were, it's interesting, Souter was the same, but both Republicans, but both ended up on the liberal end of the court after having to deal with the real questions and deciding what the right decisions were. But I think the confirmation problem is, or a process is a real problem today. These people, Gorsuch, Kavanaugh, Amy Coney Barrett, have been sort of almost, not groomed is the right word, but they have been approved and pre-approved by the Federalist Society, which has a very conservative agenda. So when they come before President Trump, he says, these are justices who share my ideology. Brian, I just think it's important to stop and think back about Roosevelt when he had a chance to replace almost all of the justices of the court in the late 30s, early 40s, systematically adopted, proposed, and got approved New Deal sympathizers. So it cuts both ways.
Right.
It cuts both ways. And we tend to get upset, I think, when conservatives then implement conservative ideology. But I can see conservatives perhaps feeling the same way about the New Deal justices who quite happily overruled the earlier cases by the previous conservative court. So it's not new, but the confirmation hearings no longer, I think, are very meaningful. I think there is a difference that generally the candidates that were nominated up until, fairly recently, were nominated on the basis of capability and were approved or disapproved. And there was genuine discussion and inquiry at the confirmation hearings, not so anymore.
So when we talk about things like privacy, it's interesting to me that, you know, we do get people that are thinking, that see, you know, two sides to it. You see somebody like Justice Kennedy saying, you know, someone's sexual intimacy is a private matter. And then you have justices that will say, no, it's not. I mean, does the Constitution say something about privacy? Was Kennedy right, or was he willing to sort of, you know, he realized that the time was coming where we needed to move beyond this kind of issue?
Well, that is such an interesting, and it continues to be a controversial question in the Constitution, because there is no right of privacy in the text of the Constitution. The court is precipitated through the due process clause as the basis for finding that there is and ought to be a constitutionally protected right of privacy in our constitutional system. The due process clause says basically one statement, any law that deprives a person of life, liberty, or property without due process of law. And the notion is the framers of that amendment meant something when they talked about protected liberty. And if you're going to deprive somebody of his liberty without at least having a compelling reason for doing so, you are violating the due process clause. The start of this all was a Connecticut law that was challenged back in 1965 in a case called Griswold versus Connecticut. The Connecticut law, which had been on the books for eons and eons, made a crime out of the use of contraceptives. Married couples would be hauled into jail for having used contraceptives in the privacy of their own bedroom. And the court looks at that and says, that just is so inconsistent, not just with our sense of protected liberty, but with the framework's sense of the relationship between government and individuals. There ought to be a sphere of protected liberty. And so they believe that was the case. They struck down the Connecticut law. It was a divided court. They struck it down and said this violates a fundamental right of privacy that married couples ought to enjoy in the privacy of their own bedroom. Justice Douglas has this famous image, and he imagined the blue meanies, the cops coming around, searching the marital bedroom for telltale signs of the subconscious. Hey, if our Constitution means anything, you can't, that violates. Well, the next case that comes along is the Eisenstadt case about 5 years later. That law didn't prohibit married couples from using contraceptives, but it made a crime to sell and for unmarried couples to use contraceptives. So Justice Brennan, writing for the court, said, I can't talk about the sanctity of the marital bedroom now. I can't talk about the sanctity of the marital relationship for those. But he said, you know, if there's any decision that is fundamental in our lives, that ought to be protected from arbitrary governmental, it's the decision whether or not to have kids, right? Whether or not it's the contraceptive decision. If married couples enjoy it, well, so individuals ought to enjoy it too. So you notice, right of privacy expands a little. In the next case is Roe versus Wade, and you can see the logic of the court saying, oh, if we're talking about decisions that have a fundamental impact on the life, the decision of whether or not to give birth to a child or to terminate a pregnancy is one of the most fundamental decisions that anyone can make. So the court said, this too falls within the sphere of protected privacy, and government cannot interfere with it unless it has a compelling interest in doing so. And then the court went on to say, states don't have to ban abortion anytime during the full 9 months of pregnancy, but they can do so before viability, before this point where the fetus is capable of life independently outside the womb, which roughly corresponds with the beginning of the 3rd trimester. So that's what the court said. States don't have to, but at that point they have a compelling interest, if they want to assert it, in protecting the life and health of the unborn fetus. So that's Roe versus Wade. But you can see how it naturally follows. And so now what the court has begun to do is engage in analysis of are those decisions whether to like these decisions. But such a fundamental impact on your life if the state interferes with your interests. So that's where it all begins, but it's not in the text of the Constitution, except that it's roughly grounded in the liberty term.
So then do courts make decisions based on prior decisions? It sounds to me as though you were talking about this almost step process to the point where they were able to get to Roe v. Wade. Does that often happen? Is that sort of what, if looking out here at students, would you say that's somewhat accurate?
I would say it's somewhat accurate. But here's the Constitution. In an ordinary textbook, it occupies, with all 27 amendments, which occupy more than half, maybe 13, 14 pages. There is their done. There's some provisions there's no argument about. You have to be 35 years old to be president. You have to be at least 30 years old to be a senator, 25 to be a representative, and a couple of other mechanically applied criteria. But there's so many provisions that are open-ended. So For those of us who practice constitutional law, we look at the Constitution not as sort of a set of rules, but a set of problems. Right? The Equal Protection Clause prohibits racial discrimination. Easy enough. But does it prohibit affirmative action where you take race into account to deal with the fact that you're dealing with people who have systematically been discriminated against since the beginning of the law? Does the federal government have the power to prohibit or ban abortions throughout the country? Where do we get that power? You can read the list of 7 or 8 powers the federal government has. Nowhere talks about a power to regulate the abortion procedure. Do states have the power when there's an energy crisis to favor in-state residents over out-of-state residents? So a whole set of questions to which there are no answers in the text of the Constitution. And to answer your question, what the court does then is it looks to precedent and reasons by analogy. We decided that in that case, this is pretty similar to that, all is different in this respect. How should we come out? It's actually, it's interesting that for all the chaos and uncertainty and controversy surrounding constitutional decisions, the process of arguing, how am I going to interpret this clause? How am I going to find whether or not the right of privacy includes this or that, is really quite civilized and well established. You argue from precedent. You sometimes invoke the historical understanding. It ought not to limit us completely, but that's not irrelevant. You argue from the text sometimes. What's missing from the constitutional text that was in the articles? Does that make a difference? You argue about structure. Can the states tax the entities of the federal government? Well, Chief Justice Marshall said, I'm concerned about that because if they're allowed to do so, it might well make it impossible for the federal government to perform the functions that have been assigned to it. So a whole set of techniques for arguing about how a new case should be decided, but arguing from precedent, Brian, is the primary.
So when people talk about being an originalist, I think it was Scalia who talked, prided himself in some ways about being an originalist. So they're not necessarily looking at precedent, or is it that they are just going back to the document itself?
Originalism has, or trying to understand the historical understanding of a provision in the Constitution is important. But originalists really abuse that. They often cherry pick history, and they just happen to find those strands of history that coincide with their own, oftentimes we like to think, conservative political views. So I think it's I think most scholars agree it has some usefulness, but it also is loaded with potential danger and misuse. We ought not to be, as simple as this, look, we're all living with it. We ought not to be locked into a view of the world that was embraced by the framers in a time that was very different from ours at one level. On the other hand, if they had a vision, we ought to allow that vision to inform our decision today. So it gets tricky.
People have questions, feel free to raise your hand and we'll jump in. I just want to continue a little bit unless I see somebody's hand go up right now. Eric, you want to jump in?
I have a question about the number of justices on the court. It seems that America has a small number relative to many of the European countries for their Supreme Court. Can you speak to, there's been discussion about expanding the court. I think it's called packing the court if you're against it, but it's really keeping up with the number of the population growth and the complexity, the number of cases that are coming in.
Well, Eric, that's a really important question. First part of the answer, There have been 9 justices on the Supreme Court since roughly after the Civil War, 9 justices. But over the course of its history, the court has been composed of as few as 5 justices and as many as 10. And there was quite a lot of fluctuation in the period before the Civil War. Why? Because during that time, the justices had to do what we call ride circuit. That is, they sat on the Supreme Court, but they also had to join justices on the courts of appeals throughout the country in their various circuits. They actually had to get in the wagon with the wooden wheels and go out there and ride over and participate in that way. And so during that time, Congress, as the country grew, began to expand the number of circuits, originally from 5 up to as many as 10. And it fluctuated a little. And then during President Johnson's term, after the Civil War, not a very popular guy, Congress didn't want him to be able to appoint another justice to the Supreme Court if a vacancy developed. So they adopted a law saying that vacancy will not be filled. That's how we bounced back to 9, and that is where we have stayed ever since. But the Constitution itself does not prescribe the number of justices. The number of justices can be established by Congress. There should be 1 Supreme Court. It shall act as a trial court in just a couple of very limited situations. And other than that, it should act as an appellate court subject to such regulations as Congress deems warranted. So it can limit the jurisdiction of the Supreme Court. It can add members to the court. And you want to know, can Congress do that? The answer is constitutionally, Congress can. It can add 2 justices. Let's just figure this out. You've got 6 conservative justices. How many you want to add? They're 9. So I got 3 liberal justices. How many do you want the current Congress to add if you could have your way?
Well, 4, 5-4 would give the majority, right?
Then you'd have 7 to 6 with 4.
Yeah,
Yeah. Okay. Can be done. 1, you got to have a 60 vote majority in the Senate to do that. Okay. Not very likely unless we get to work during this upcoming election and do things that nobody thinks is likely or possible. 2, President Roosevelt, who just rolled in office with overwhelming majorities in both houses, wanted to expand the number of justices on the court, and he proposed it because I said, I got a bunch of conservative old fogies up there. They're frustrating our ability to adopt legislation to deal with the Great Depression. And there was interesting resistance to that on the part of both conservatives and liberals who thought this was kind of a political manipulation of the court that was inappropriate with the role of the court in our society. But it can be done, and increasingly there are advocates who say we ought to add at least 2. If you add 2, it's interesting what you get. Then is you get 4 diehard conservatives. You get Justice Roberts, who's conservative, but a little more on the liberal end. And then you would have 4 liberals. So that might be a little more palatable. And maybe we could get by with that because Roberts is aware of his legacy and the reputation of the court. So that's another possibility. It can be done, but it's highly unlikely.
And I think out there in the public, I could be wrong. I think some people just think, oh, Biden can go and appoint somebody tomorrow, but that's not the case. Congress would have to authorize additional seats.
Congress would have to authorize additional seats, and then the justices that he nominated would have to be confirmed by the Senate. So I think people who think about it say, boy, that is a real uphill climb. But if the court continues its current course and the approval rating of the United States Supreme Court after the Dobbs decision overruling Roe versus Wade dropped precipitously. Over the past 2 years, it's dropped from around, and there are different polls, but one Gallup poll says from like 40% approval to 25% approval. But the court can only operate so long if it is constantly making decisions that are so out of line with what the public wants. That's a long-term wisdom, but it's a kind of check. It's not a very good one, but it's at least a kind of check against abuse of the judicial power. So, oh, Eric, I was just going to add one other thing. What's the other possibility? Could you have term limits? Every European system, constitutional court system, has limited terms for justices. In Spain, for example, 9-year terms, in and out, that's the beginning and end. Our judges, this is one other thing our Constitution requires, all our federal judges are appointed during good behavior. Translation, that means lifetime appointments. What you can do and what people are contemplating is saying, you can continue to serve as a federal court judge, but we're going to remove you from the Supreme Court and put you on some court of appeals and senior status. And that would comply with a during good behavior request. So people are exploring these options because of the concern that I raised at the outset that we got a court that in the long term represents real threat to some of our democratic institutions.
Susan?
On?
Yeah.
So this is a question from our online community, of which we have a bunch online right now. Because there is a class here and online that has to do with international law, the question is, what relationship do you see the Supreme Court has to international law? Do they influence it? What's the interaction?
Well, that's a good question. There are two ways to think about it. One is, what has been the influence of the United States Supreme Court and its decisions on Supreme Courts and on the European Court of Justice, which is the European equivalent of the Supreme Court? And the answer is some of the early decisions by John Marshall asserting judicial power of review, coming down in favor of strong central government, have strongly influenced the decisions of European court justices. But when you look at it the other way around, Antonin Scalia, one of the funniest guys that ever sat on the court, but also a diehard conservative, he would go haywire at the thought that our constitutional system should ever be in the slightest influenced by what some of these European courts or socialist courts in other countries are deciding. He thought that comparative law could play no role in our constitutional law system. On the other hand, you have justices like Kennedy, who in the Lawrence versus Texas case, in which the court struck down Texas's law, which made it a crime to engage in homosexual sodomy, or I don't know how, there's probably a better way to put it, but he struck it down, and he said, look, the tendency within this country has been to eliminate this as a criminal activity, but also among enlightened countries abroad. This is not considered anymore a crime. And we ought to think about that when we're deciding what our own constitutional standard will be. So it can play a role, but it makes a very rare appearance.
In regard, does the Supreme Court ever have any connection to the International Court on human rights? Because we've signed on, right? The United States has signed on to the Declaration of Human Rights in terms of, and the torture, when I think about the torture cases during the Iraq wars, but does that ever go up through the Supreme Court, or is that a totally different pathway that our country would, that you only go directly to the United Nations, you don't go through any of our court system?
Well, it's a little bit more limited than that, but the Supreme Court must enforce not just the provisions in our Constitution, but other provisions of federal law, including those that are contained in treaties that we have signed. So in that respect, the court will apply US treaty provisions that in fact involve an aspect of international law, but it's not because it's international standards. Absolutely the opposite, by the way, in European courts. Oftentimes you find in European court decisions a reference not just to national constitutional standards, but the standards established, say, by the European Court of Human Rights or by international commitments. But US tends to be a little bit, I don't know, what's the term for it?
Provincial, maybe not.
You know, provincial or just that notion that the US is special and doesn't need to trouble itself with what other people are doing. I disagree with that completely, but that has been the pretty consistent policy. So if you can sneak a little international law or international standards into constitutional argument, which people try to do, all the better for you.
I want to go back to FDR. You mentioned had considered this idea of increasing the number of people on the court. You said liberals and conservatives both said, seem to be opposed to it. Why in the end, why were they opposed to it? Why did they get to the point where he decided not to?
Well, there were a number of elements there. One was he was getting resistance from some of the strong liberals on the court itself. So Roosevelt's plan was, I'm going to make this neutral so it doesn't sound political. I'm just going to replace every judge on the court that is over 70 with another justice. Well, old Justice Brandeis, who was an angel of fire when he got angry, said, hey, wait a minute. I'm over 70 and I handle twice the work that any of my younger colleagues could do. So he was getting resistance from liberals on the court. But the real answer is, and it's often referred to as a switch in time saves 9. One of the conservative, it was a closely divided court, 5-4 conservatives. One of the conservative justices began to get a little bit nervous. If we keep on this course, maybe they will add justices. And so in a crucial case, he switched from the conservative side to the liberal side. And then some wit said, a switch in time saves 9 because it ended up saving 9 justices. And after that, the old fogies on the court almost systematically retired or died off or became sick. And within a period of 2 years, completely replaced with New Deal appointees.
Students, other student questions? Yes.
Okay, so you talked about the action of adding members to the board. What about removing, just like reducing the size from 9 to say 7? Is there a way to do that, or?
There's no way to do it because the justices are appointed during good behavior, which means everybody says, unless they really do something that is illegal or treasonous, their appointments are lifetime appointments. So you have to wait. But if they die or retire, it is perfectly possible to say, for Congress to say, we will not replace those. We'll go down to 7. I don't know that if you're concerned about the conservative liberal divide, that's likely to enhance the liberal position, but you could do that. Yeah. And that's what happened when President Johnson, after the Civil War, an unpopular president, was in a position of appointing another judge. They said, no, we're just, if a vacancy occurs, he's not going to get to appoint anybody.
Earlier you mentioned something about public opinion being some sort of limited ability to check the Supreme Court. Can you elaborate on how exactly that would take place?
Okay, help me with that one.
So how would public opinion, how does it provide a check on the Supreme Court? I mean, we see in some instances, there has been, gay rights, privacy issues in the past, public opinion had gotten to the point, but now it seems as though public opinion isn't really being taken.
I guess my thought is if or the majority of the Supreme Court decides that they don't care about ruling in favor of public opinion and they don't care about taking public opinion into account, is there anything else public opinion can do to compel them?
Well, that's a good question. It probably operates in a fairly subtle way. But one, the court prides itself by saying, we make unpopular decisions. You can stand outside the court and protest from dawn till dusk, and it is not going to make any difference. If anything, it'll just steel us in our resolve to make an unpopular decision. So the court prides itself on not responding or deciding cases based on what is politically popular or not. On the other hand, if the court continues to make decisions and generating widespread national criticism, that does operate, not for every justice. I think Justice Alito probably would relish that. But Justice Roberts is very much concerned about the court's role in history and the perception of the court. And if he gets the sense that the court is increasingly putting itself in a position of being simply a partisan hack, that is something that he doesn't want to see. So it might have an influence on some of the justices, but certainly not all of them. Yeah.
I'm gonna pass the mic back there.
So I read that you were involved in advising lawmakers on drafting Prop 5 or the Reproductive Liberty Amendment for Vermont. And so I was interested to hear about, like, if Prop 5 passes this upcoming election, how do you think it will change like daily life in Vermont and the wider US? Thinking about specifically, would it provide greater protection and like funding for other reproductive services, in your opinion?
Okay, so the question is about what's called Article 22, Proposition 5.
Proposition 5.
Yeah. Proposition 5, basically, it does something a little different, but it basically just puts into the Vermont Constitution an amendment that would do the same thing that Roe versus Wade did. That's all it does. It says reproductive rights are protected and they can't be interfered with by the state unless the state has a compelling interest for doing so. So that means if the state doesn't pass any legislation, a woman could, as a woman can right now under state law, decide to have an abortion during the third term. It's very rare, but could, because of personal needs, because a discovery that there are fetal anomalies that mean that that baby will die within 2 days after being born, could obtain a third trimester abortion under this state law. If the legislature of Vermont decides, on the other hand, that the state has a compelling interest in protecting the life and health of that fetus, say after viability at the beginning of the third trimester, Prop 5 allows the state to make that decision. So it does nothing that Roe versus Wade didn't do and doesn't do it any differently. Now, does it going to protect a woman's right to choose in Vermont if Congress passes a law banning abortion nationally? No, because a federal law, duly adopted federal law, trumps even state constitutional provisions. So it's not going to, and it certainly wouldn't protect the woman's right to choose if the Supreme Court should decide, it's been proposed, that a fetus has a constitutionally protected right to life from the moment of conception forward. Therefore, any state law that allows a person to choose to terminate a pregnancy violates the fetus's constitutionally protected life. So there are a couple of situations where that amendment just is not going to do any good. But it's such an important symbolic statement nationally and locally. This is our commitment. This is where we stand on the issue of whether a woman ought to have a right to choose to make this very, very important decision. And it's often not just the woman, it is the whole family. So anyway, that's what it does. And that is its limitation.
Did the Dobbs decision surprise you?
What?
The Dobbs decision, did it surprise you?
Yes,
It did. So you anticipated perhaps the justices, based on what they had said during their hearings, that they would indeed hold up Roe.
well, maybe I answered that, but could I strike that answer? Your Honor?
Absolutely. Rewind the tape.
Look,
Yeah.
Roe versus Wade, establishing a constitutional right to choose, was solid precedent in this country for a period of 50 years. It was followed consistently. I can't think of virtually any case in which it was even a problem by both state and federal courts, as well as the Supreme Court during that. There was a moment when there was some concern about whether it might be overruled, but that was deflected. So you got a 50-year precedent, which has been approved and reapproved and reconfirmed by so many justices on the court. And to have the court then turn around and say, Roe versus Wade, when it was decided, was clearly wrong, and that's the standard. In order to overrule a case, the court has very clearly said it's not enough to disagree with that earlier opinion, because we want the law, especially constitutional law, to have a certain semblance of stability, a sense that it transcends the passing whims of the law. So disagreement, not enough. In order to overrule a decision, you have to find it was clearly wrong. And you listen to Justice Breyer in oral argument, he hammers away at that point, clearly wrong. And so it surprised me in the sense, because I don't think anybody would say, there are problems with the gate, there are problems with the viability standard, but to say establishing the basic right was clearly wrong, I think is a real stretch. Now, how did the court do that? I will tell you how it did it in two ways, which are really important. One, it said when the 14th Amendment was adopted, that's got the due process clause in it. Okay. Which got the liberty term in it. When the due process clause was adopted, 3/4 or more of the states made a crime of abortion at any point along the way. So the framers of the 14th Amendment clearly did not anticipate or contemplate that it would become the source of a constitutionally protected right to choose. And then the court starts to get a little nervous about that, because the same could be true about interracial marriage. That was a crime in many states at the time. There certainly was no right to consensual sexual intimacy on the part of adults at that time. Same-sex marriage was clearly not permitted. So if you use the 1868 standard for determining whether somebody's got a constitutional right or not, all those other rights are potentially threatened, right? And members of the court are concerned about that, and members of the public and critics are concerned about that. But then in the same paragraph, Justice Alito goes on to say, moreover, there's another rationale. So you don't have to worry about those other rights, because this is the only right that involves possible threat to the life and health of a third party, that is the fetus. So is it, whatever we're doing today has no implication at all for the other constitutional rights that have been recognized as part of the right of privacy by the court over the intervening years. So I was surprised in that sense, but then you look at this court and you say, it's not surprising in that sense. I think the court was actually, Alito and the other justices that joined him, except Roberts, were quite anxious to find an opportunity to overrule Roe versus Wade. You might be interested to know about Justice Roberts' position in that case. He didn't want to overrule Roe versus Wade. This was a challenge to a Mississippi law that limited abortion to the first 15 weeks. He said, I think that law is okay. It doesn't meet the Roe versus Wade standard, but you don't have to overrule Roe versus Wade to uphold that law. You can just say the court used the wrong standard for determining when a state has a compelling interest. And the viability standard was the wrong one. 15 weeks at least gives most women a chance to make a decision that is going to have a profound impact on everyone. So he agreed with the result, but disagreed with the overall.
So I'm just want to go back to Roberts for a minute. So he ended up signing on to the full decision, correct?
Because he said Mississippi law does not violate a constitutional right. But he said also, I don't think we have to overrule Roe versus Wade to decide that. We can simply say a woman continues to have a right under Mississippi law up to 15 months, 15 weeks, and that doesn't violate her constitutional right.
Other questions? Yes.
Yeah, so speaking about Dobbs v. Jackson, when that case came out and we knew what the decision was, there was a lot of speculation that the conservative party had been making incremental moves throughout many years to then overturn Roe v. Wade. So do you think that that has been like a long-term strategy that was at hand? And do you think that that will be then used for other cases? Because I know, like you were saying, they did make the distinction that like, oh, there's a third party involved. But is that just say, or I guess like what your opinion on that is?
That's a good question. I have a certain reason not to trust, especially Justice Alito. I actually supported his appointment to the court. I'm embarrassed to say that now, but I thought he was an intelligent guy. I knew he was conservative, but I didn't think he'd be that dangerous. But he's the kind of guy that will say there are two reasons for this rule. Here's one and here's two, and they both are necessary for this ruling. And then you take the one away, and he said, well, as we said in the earlier case, this was a reason for the, and that's present here. So you could see, especially with respect to same-sex marriage, the court saying, hey, look, we're talking about the term the court uses. If it's not in the text of the Constitution, the only reason for recognizing a particular decision as falling within the sphere of protected privacy is if that decision and its protection is deeply rooted in our cultural tradition. Roe versus Wade and the abortion decision was not deeply rooted because, as we know, even when the 14th Amendment was adopted, most of the states, in fact, criminalized the abortion decision. I can hear Alito and some members of the court saying, we've used that test and we're going to use it now. That is a particular kind of decision deeply rooted in our constitutional tradition? That's the test we established in the Dobbs case. The right to same-sex marriage, not deeply rooted. The right to consensual sexual intimacy, not deeply rooted. I don't think the court will go back as far as to say interracial marriage ought not to be protected. Justice Thomas ought to have a little problem with that since he has an interracial marriage. But anyway, it's a good question because this is a court that is constantly moving the goalpost. And it may well say, we did say that life and health of the fetus was important, but it wasn't critical. What was really critical was whether the particular decision is somehow deeply rooted in our cultural tradition. Now, there's another way to think about it, and I might just share this with you. It's what most liberal justices believe. One of the most important questions you ask if you're trying to decide if a particular decision is protected is what kind of impact will that decision have on a person's life if the state interferes with it? And you can say, well, if the state prohibits you from using contraceptives, that's going to have a profound impact. You're going to have kids that you can't afford, don't know what you don't want. What if a state interferes with the right to make a decision about childbirth? You see, that's what the dissenters say. This is an incredibly important decision. It has a fundamental impact on people's lives, and the state ought therefore not to be allowed to interfere with it unless it's got a compelling interest in doing so. But that's a good question. We don't know where the court's going to go.
Hi, you've mentioned over time that judicial picks are getting more partisan. That it wasn't always this way where, like you said, the originalists are kind of picking and choosing moments in history to support some predetermined political agenda. And like even in recent history, you see like with the Merrick Garland incident, kind of parties are beginning to twist the court more towards their own ends. And it certainly seems like these suggestions of like court expansion and circulating the judges might be necessary steps to like push things back in the like back to where they were. But then also like there's a risk that it seems like that might also perpetuate the same like political stench, I think is what one judge called it. And so then create like this cycle of like the parties are now struggling for control of the court. So my question is, in the long term, are there any policies that might depoliticize the court more permanently? So like I know in India, new justices are actually selected from a collegium of existing judges. So the legislative branch actually has no control over that other than impeachment. And so I'm wondering if there's any scope for like a similar reform in this country.
So could you?
So to really to depoliticize the choices, right? To make the choices less political. And you mentioned in India, their judges sort of choose within, like judges choose other judges to kind of put them. Is there a way to depoliticize some of these choices more? Are there processes that we should consider as a country?
Well, the Constitution requires that a president's nomination for members of the Supreme Court be subject to advice and consent of the Senate. You can't get around that. That's right in the Constitution. But the processes for nominating the judges in the first place, there's plenty of room for, it might require the executive to agree to those processes, but I think a system like that has some potential. That is, you say, the decision to put a list of candidates before the president will be prepared only by recognized scholars or recognized jurists and something like that, as they do in other countries. The problem is, though, you end up with the president deciding from that list who to nominate, and then it's up to the Senate to decide whether to approve. So a little bit difficult to get around that, but I agree that there are much more intelligent ways of selecting our top jurists in this country than the one that the framers left us with.
But it does sound as though one thing to do would be for the Senate to sort of beef up its game in terms of the hearing process. You mentioned that years ago, I mean, the hearings have changed dramatically over the years. So would you say just a little bit about how they've changed? Have they been less are they less rigorous? Were they more rigorous 20, 30 years ago? I mean, I'm thinking back to the Anita Hill hearing, which of course, I mean, I was in my early 20s. That was a very rigorous process, not Anita Hill hearing, excuse me, Clarence Thomas hearing when Anita Hill was there as a witness. But how have they really become less rigorous?
I don't think rigor, more rigor or less rigor is a, first of all, think of yourself if you've been nominated to become a justice on the Supreme Court. I think those that appear before the Senate are absolutely right in saying, I can't tell you how I would vote on that, and I shouldn't tell you how I would vote on that until I've heard full argument on one side or the other. So I'm not opposed to the nominees sort of ducking the tough, how would you vote on Roe versus Wade? And so they get asked that question anyway, and they say these nice things, and then they tend to forget the nice thing they said. But it's not a question of more rigor or less rigor. It's just become, I think, just a show. Because it's primarily the senators use that as an occasion for getting before the camera and asking the questions that they think their constituents think. And the nominees give you non-consequential answers. So,
Eric?
Many things to keep us up at night and be worried. Where do you see the Republicans calling a constitutional convention and putting through a lot of extreme changes. They're very rare, but they have happened. What are your thoughts on today's likelihood?
So Eric's question refers to a proposal made by some of the Republicans that we call a constitutional convention to amend the Constitution. Now, my view is probably the Constitution would benefit from some kinds of amendments. That's basically how the first constitutional convention was called. I mean, it was, you called a convention, they thought they were there just to amend the Articles of Confederation. Suddenly the Virginia delegation walks in and puts a radical proposal on the table. And suddenly we've got something that nobody except the Virginia delegation anticipate. So that's the problem. How does it work? If 2/3 of the state ask Congress to call a constitutional convention to propose amendments to the Constitution, then the convention has to be called. The problem is we have no way of controlling what goes on at that convention. The one thing that convention cannot do, however, is adopt amendments. Once the amendments are proposed, they have to go out to the states and do not become adopted unless 3/4 of the states, in fact, approve the amendment. So there are safeguards, but the concern is that no way to be sure that that convention won't become a runaway convention. What happens to the First Amendment and the important protections it provides to freedom of speech? What happens to the Equal Protection Clause? We just don't know. So I don't think that has any real legs. There's one other way to amend the Constitution, very briefly, which is that if 2/3 of both houses, both the House and the Senate, propose amendments, those amendments go out to the states and again become ratified if 3/4 of the states approve them. That's happened 27 times, including the first 10 amendments, which we call our Bill of Rights.
Question over here.
Would something like the Equal Rights Amendment have an effect on the Dobbs decision, or does the third party clause get in the way because of fetuses?
Okay, now that's a good question. So I think it was back in the 70s, I'm not sure when, but it was proposed that we adopt an Equal Rights Amendment that would prohibit discrimination on the basis of gender, basis of sex. That amendment, in fact, was sent out to the states. I believe there was a time limit on that amendment. Amendments don't have to have time limits, but I believe when Congress sent it out, they said there's a time limit for ratification. And by the time we reached the end of the time limit, there had been an insufficient number of states ratifying it. Now, what happens if you get a couple more states to ratify it after that time limit has expired? That is one of those constitutional problems I told you about, to which we don't have answers in the text of the Constitution, but you get arguments on one side or the other of that. Yeah, I don't know that an Equal Rights Amendment would do all that much if approved now, because already the court has said the Equal Protection Clause prohibits gender-based discrimination. It might, but I just, I think it probably would do a little bit of good.
So we have about, I think, about 10 minutes left. So if the courts are in this moment of crisis in terms of our democracy, and they're contributing to, democracy becoming weaker, what can we do to beef up make the courts stronger, make them, is there any way to hold them responsible besides, what we've talked about, which sounds almost impossible? The adding members might not be the best idea, but doing term limits, that kind of thing. Is there anything that one can do? I mean, we look at Congress, we look at the presidency, we have tools in our toolkit, if you will. Maybe it was the founders' ideas that we can have tools in our toolkit to interfere with the court.
Brian, I'm going to have to give you a frank answer. I think doing something about the court is a real problem. What we can do, and it is maybe weak tea, but it's absolutely crucial, is mobilize politically. If sometime within the next decade or so, we see a Congress in which you have the Democrats representing at least 60 votes in the Senate, and a Democrat as president, and a Democrat majority in the House, you can do an awful lot to change the course of the corruption of our institutional life legislatively. But one of the interesting, almost ironic side effects of the Dobbs decision has been the way, I think unintentionally, it has mobilized the electorate around the issues of women's rights and around the issue of abortion. If it has that effect, that's going to have important implications. Let me just give you one. If you have a Congress that, a Senate that is where you've got a supermajority of Democrats or liberals or whatever people who support a woman's right to choose, you can adopt a national law that supersedes laws in all of those conservative anti-abortion states that says you have to allow a woman. That can be a statutory right, and that statutory right trumps, I hate to use that word anymore, but I have to, trumps competing state law, even competing state constitutional law. I say it might be weak tea because that involves incredible amount of work. And I think that also involves, you got to be sort of politically realistic. Is it attainable? But mobilizing politically is perhaps the best, at least the best, most realistic way to respond to what we see as not so much a crisis of the court, but a crisis of our institutions that the court has contributed to.
Susan.
So if democracy is, and the way our Constitution was set up, if you agree with this, it was to figure out how to mediate differences among the population and how things were represented. And so the different parties all along historically, whether now we're in Republican, Democrat, liberal, conservative, progressive, independent. So there's always going to be, right, things that any of us disagree with. And so where I think there's a lot of confusion is that we use the word conservative to represent truly irrational behavior that I'm not sure is even conservative at all. And so I think there's confusion even among the populace that there's a lot of this partisan now serious fighting over trying to, and I think Biden is trying to separate now the MAGA wing from a conservative view, okay, with the checks and balances of our government and how that was supposed to be set up. So I guess my question is, the courts did hold up with the, the statements about fraud in the last election, right? And even the Supreme Court, given the way it's constituted, did stand up, did not contribute to overturning the election, which is not to say there's not tremendous, problems now, the way the state legislatures are interpreting law and whether the Supreme Court will interpret it, that legislators have more power than what we may think. So that seems like another issue going forward. But I guess the courts did hold up conservative judges and liberal judges. So I guess what I'm asking you is, do
Keep
you
on
think our
going.
Constitution, do you think our Constitution, when it comes right down to it, with all its flaws, and it's evolving, can really hope, like, work its way through if it really is about this mediating difference and trying to, or is this irrational wing that has now seemed to intimidate and manipulate most conservatives to go along with them? Are we too far so that only one party now really can be responsible, or can we actually still continue to mediate these differences?
Well, Susan, that was a long question, but it was really an important question at this point in our discussion, because I feel a little bit guilty about having thrown the term conservative and liberal around as if it was pretty clear liberal was good and conservative was bad. And what Susan is asking is that really the dichotomy? Is it descriptive of where the problem lies? And I think that's an important question, because I don't believe that. I think there is an important role for conservative political ideology in our political system, responsibly expressed. I think extremely important role. Those people who say, hold on just a minute, we have these traditions, they really are important. Before we abandon them, we ought to ask carefully whether that in the long term, that will benefit us. Okay. And so what Susan is simply saying, isn't really the distinction we want to make between conservatives and use of MAGA, irrational arguments, conspiracy theorists. I think politically speaking, that is, you've got the distinction right, that's the distinction we want to make. The problem I have is I'm dealing with a court of 9 people. I can actually see the spectrum when I look across in my mind at the justices sitting there, and I see the liberal wing and I see the conservative wing. And so that's the sense in which I was using it. But many of those conservative justices, and I think of Roberts in particular, have contributed importantly to constitutional discussion. So it really is the quality of the contribution and the thoughtfulness that matters, rather than just, whether it's left or right. Yeah. But that's a really nice point to bring our discussion pretty much to a close.
Pretty much. I'm just going to ask finally one thing, if you would. You've watched the courts, you've read about the courts, you know the courts extremely well. Not asking you for sort of a best and worst, but tell me a justice that you really in history admire, and then maybe one that has you look back in history or maybe today that might not pass muster in terms of your understanding of who should be on that court.
One of the justices I admire tremendously is a Republican justice in the end of the 19th century, Justice Harlan, the first Justice Harlan. There's a famous case called Plessy versus Ferguson, which involved a challenge to a Louisiana law that required blacks to ride in black coaches and whites to ride in white coaches. And the court upheld the Louisiana law, saying the Equal Protection Clause prohibits political discrimination. It prohibits discrimination with respect to jury service and things like that. But it cannot and does not prohibit social discrimination. We inherently are birds of a feather and we flock together, and law is powerless to bring people together. And they said, look, it treats both blacks and whites equally. Whites can't ride in black coaches. Blacks can't ride in white coaches. And Justice Harlan pierced right through that. And he said, everyone knows what segregation laws are all about. They are not about equal treatment. They have one and only one purpose, which is to keep the recently emancipated black race in a position of legal, social, and political subjugation. He didn't cite a single psychologist or sociologist in doing it. He just said, everyone knows. And he said, it will be a long time before we atone for the wrong this day done. That to me is really a beautiful constitutional performance. I happen to think that the second Justice Harlan, also a Republican appointee, also was very, very good. And one of the things he always said, and this court disregards it all the time, he said, when we're dealing with highly controversial social issues, it's crucial that this court move in especially measured steps. This court has not been moving in especially measured steps. It's gotten out the sledgehammer and taken it to existing precedent in ways that are sometimes shocking. So those are the good guys. Yeah. I'm working on a biography which will never be finished of a guy named Thomas Reed Powell, who came from Richford, Vermont, but it was a very famous constitutional law professor at Harvard. And he was always called upon to pass judgment on nominees for the court. And when Justice Rutledge was nominated, he said, he wrote back, I can't remember, probably his friend Frankfurter, he said, you know, the guy's virtues is that he's really mediocre. You need mediocre minds on the court to balance off all the bright minds that are all. He had a pretty short stint on the court and proved Powell's prediction fairly nicely, but sometimes Justice Black, who was the arch libertarian on the court, can really get me angry because on some matters he just was intolerant and irascible. So, but anyway, I've given you the good guys, and that's what really matters. Yeah.
We have some cookies and lemonade out there. If hopefully Professor Joe might just stick around for a few minutes. If anybody has any additional questions. I do want to say in Montpelier, I'd say in the state of Vermont, Professor Teachout is a legend, and you run into any of his former students at the State House. They talk about having to work hard in his class, and those that really would go in there wanting to earn his respect. And you can see why from tonight's conversation. Appreciate everybody who is here, and I certainly appreciate those who zoomed in, but most of all, Professor Teachout, thank you for making the effort, and thank you for Judge Teachout for joining your husband this evening with us. Thank you.
Thank you. So I want to throw something back at you. First of all, Brian, do you give these people extra points for raising questions?
No.
You have been just such a tremendously attentive, intelligent, thoughtful group to talk to. It really, I just am impressed, and it's been great for me. And I also appear occasionally before Chairman Campion's Senate Education Committee. And as I was saying at dinner tonight, it's an example of democracy at its best, a group of really thoughtful legislators dealing with difficult problems in thoughtful and intelligent ways. It makes you really proud to be a Vermonter and be part of a democratic system that really works. So thank you, Brian.
Thanks, everybody.